So let me just say that there are a few things I want to cover here, both in terms of the events of 1801 and 1803, but I also want to talk about what's significant now about these cases at a time where the questions of courts and constitutional law are probably as significant as ever in American history. And I want to leave plenty of time for questions, so if you want to ask questions about these cases or Marbury, and I'm also going to talk about Stuart v. Laird. In my opinion, just to give you my overview about the history, at the time, when I was doing I had a chapter in my book on Marbury and in the context of state cases. You can go on Amazon.com or your local bookstore. Actually, no local bookstore is going to sell this book. So the thing that I was looking at the time, I pulled up old newspapers from 1803 to see, in February of 1803, to see how they covered these cases. And Marbury got second billing. In fact, it was footnote. Stuart v. Laird was the much more significant case. So the Stuart v. Laird issue about the federal judges, they knew at the time that was the real show. That was the real showdown. What Marbury was basically a cop, right? It was the commission for a police officer. So I'm only exaggerating a tad, but that is a lower level position compared to the big fights we have today over precisely the kind of judges the intermediate appellate courts today decide so many big issues. That was what was at stake in Stuart v. Laird, and so I want to put that in context. I'll say just in the bigger point here is that everyone was looking at those cases to see whether the Federalists, all of those midnight judges, all of that effort that the Federalists tried to preserve their power after Jefferson was elected, everyone was looking at that, and that issue they lost. And not only did they lose it, right? I encourage you at some point, if you're interested in looking at it, go pull up, you can find it online, you can look at the decision in Stuart v. Laird, and it's basically 2 paragraphs. So you've read Marbury. Marbury is a lot, right? It's a lot to read in Marbury, a lot of moves, there's a lot of Latin, right? And there are a lot of stages of the argument. That was all the big argument they made about the less important case. For the more important case, they gave it 2 paragraphs. I think that tells you a lot about what Chief Justice Marshall was trying to do in the court, is trying to hide the ball, right? Trying to say, I'm not going to use the big case to say anything because it's kind of embarrassing that we're going to lose it. So I'll come back a step. But let's just make sure we review. So before I talk about Stuart v. Laird, I just want to make sure that we understand each of the steps. And stop me, and please, raise hands at any point if you've got a question, right? But the 3 steps of Marbury, well, let me ask you, if you were to think about Marbury as 3 steps, three steps of a legal argument, right? How would you organize it? How would you think about it as 3 steps? Yeah, what's your name?
Ezra.
Ezra, go ahead.
This is what Article 3, Section 2 says. This is what the Judiciary Act of 1789 says. And then, we think, because of Article 3, Section 2, and the Judiciary Act don't align, that we have the power to.
Great. I'm going to call that the 3rd step. There are 2 steps that happen before it. And it's important to keep those all in context because they all matter together. It's part of the puzzle. It's part of what I think is the historical puzzle of Marbury. But you're exactly right. This 3rd step is taking the constitutional text of Article 3, Section 2, right? And it compares it to the 1789 Judiciary Act. I want to come back to this, right? So let's take a step back. I want to first figure out what maybe the first 2 steps, and Ezra will come back to this. So yes, what's your name?
Sure.
Sure, go ahead.
Does the petitioner have a right to face inquiry?
Is there a right? So tell me more about that. Tell me more about the right.
So I was kind of asking, Marbury is bringing a suit,
Yeah.
and it's is this a legitimate suit? Is there anything he can actually gain from this, or is he just kind of being ridiculous?
Right, okay, so first the question is there a right, and does he have a claim, right? Okay, so say a little bit more about that. Anyone else want to set some other hands up? How would we frame this? What's the argument about why he has a right? What's your name?
Zach.
Zach, go ahead.
Has a wrong been committed? And is there a remedy for that wrong?
That's the second step, right? So these are two sides of the same coin. The first point you made is there a right with respect to Marbury? The other side of that coin is, was there a wrong done by Jefferson and Madison? So that first step is, now the way that the court is also focusing on it is thinking about that right as a property right. Does a person have a property right to from a piece of paper to an office? When we usually think about property, when I ask you about property, what's the first thing that you think about? Property. Land, right? The quintessential, the image that comes into our head, and where property was built its legal standing was on real property, real estate, right? And so we think about land. You could also think about, a house or a car, etc. We think about tangible things. It is a bit of a leap to ask, I think there are a couple leaps here. One is to think about property from the obvious paradigm, the thing we imagine about being land, houses, tangible property. Then you think about, we could also talk about intangible property, the right to an idea, intellectual property. But these are all private ideas. There is so we can think about land, then we can think about, intellectual property and things like a credit card number. Courts think about, if you have someone steals your credit card number, courts will say that credit card number is property, right? Because it's your access to your wealth. So intellectual property, or call it intangible. These are two leaps. There's a bigger leap. It's not obvious that anyone has a property right to a public office, right? If my public office is created by a legislature, is it obvious that I own a public office, right? If I'm working in an office building, I can't suddenly declare, well, this office I'm working in, I'm going to move a bed in there, and I move my kids in there, right? My office, my actual office in an office building is a public office. Do I own it like property? Like I could start selling, kosher hot dogs out of it, on my own spare time. It's not obvious, but it actually is an important point to look at the fact that Marbury's office, a public office, he has a property right in it. So let's make sure we see each of these steps as being significant and a major move by Chief Justice Marshall and the Marshall Court to identify public offices as something that has an individual right to attach to them. Now, I looked at this study in detail, and I looked at the English cases on this, and it turns out English law has a whole set of property right interests in public offices. We don't see this now, but in England, the royal family would basically create permanent offices for the aristocracy that you could hand down from one generation to the other. It sounds crazy now, right? It sounds crazy when we've got, different Clintons running for office, and we have Trumps and Bushes. There is something dynastic in American politics. There's a Kennedy always in politics, so there is a dynastic element to our democracy, but that dynasty aristocracy was a law of offices in England. The funny thing is that when Marshall says that Marbury has a right to his public office as property, he's partly borrowing from aristocratic monarchy ideas about how nobility can hold offices for one generation to another. Lador vador. I don't think you use that phrase. More Latin. Okay. So that is the first step. And then was it Zer? You said then the question about a remedy. Right? Who said, you said remedy, right?
Yeah.
Yeah. So then after this major move here of the public office, so shifting from that Hebrew lador vador to Latin, remember this, what was the Latin phrase about a remedy? Does anyone remember it? It's ubi?
No, that's it.
Did you see this one?
That's
Ubi.
that's another Latin term. We haven't looked at this term.
Okay, no, this is the phrase here that comes up. I think I spelled this right. I'm not sure. But it says, where there is a right, where there is a law, or where there's a right, I'm going to add a comma to the Latin, there is a remedy. So when you have a right, you also have a remedy. Okay? That makes sense, right? Yeah, go ahead.
I I just have a question about the first part.
Oh yeah, please, go ahead.
If he has a right or like property of the office, then why does it matter if he gets his commission delivered? Like, what's the big deal?
Great question, thank you for asking that, because there are two steps here, right? Because he doesn't, and that's, let's just pause there, because this is a crazy part of the story, right? You have, so who fails to deliver it? Do you remember? Who makes the mistake in not actually delivering it? Marshall himself, right? So let's get this straight, right? You have President Adams filling out commissions, but with burning the midnight oil, literally burning